Well, hello there, people. I hope everybody's good. Well, the people that I like. I'm with the Shade Brigade, so we like to wear shades, especially when we're talking shit. Not blue blockers, shades. But I digress. I also there's a few things about the Lindsay Clancy case that are not making sense to me. Um, the fact that they didn't even blink an eye at Patrick Clancy. They asked him no questions. He was not asked to provide any information, data, nothing like that. Nothing. And there was a history there. And that history can be told without bringing up the kids, without even talking about what they went through, without talking about all that. There's a story there. Um, and I will say a few things about that. And then I also want to talk about I gotta make myself look smaller because I don't know why. I just feel weird. Like I don't like people looking at me. Anyway, um, I also was sitting here thinking yesterday, a journalist is supposed to be held to a higher standard than, say, a normal citizen. Um, Someone like Karen, who was a defendant during a murder trial. Trying to get this right here. So she was a defendant during a murder trial. She is not ethically bound by any laws, rules, standards, moral compasses. She wanted her story out there, which is fine. But the way it went, it was just a one side. One side. Turtle Boy's side. The side that he wanted people to believe so that he could control the narrative. Because as long as he controlled a narrative, he could control the players in that narrative. He can manipulate evidence. He'll have you charged with wiretapping, even though that's what he does all day. The way he treats women, and the fact that he is even blaming Karen, even saying, oh, she told me to do it. Are you fucking serious? How old are you? How old are you? Trying to blame somebody else for what you said? For the lies you spread? For the defamation? For the pain and suffering you caused these people? Because all you cared about was the money. That's it. You didn't care about telling them the truth. You never cared. And I knew that. I knew that from jump. And you knew that. So I was looking into let me make these letters bigger so hopefully I don't have to use my real glasses here. Oh, Valhalla. Come on. Cut the shit. Jolene, I don't even know. You look like one of those poor little white girls that we used to like gang up sometimes in the bathroom when they didn't, that's what you look like. I'm not making fun of you. I'm not saying that bullying is okay, but you are weak minded. And that is clear. Your self esteem is shot. That is clear by the way you knock everybody. Lauren, common sense investigator. Who else is there? I had a list. Common sense investigator, expert, the baker, turtle boy, Arkansas bestie. Is that bitch for real? Like, I know that has to be like a joke. Someone tell me it's a joke. Who's Olap? Video Jesus. Pink Lemonade. Pink Lemonade is involved with a lot. A lot. A lot. If I were anyone who lived in Pensacola, Florida, on around or around it, I would like to think you have title insurance because Lauren Katie Vellucci, Lauren Edward Moore, Lauren Katie might be the owner of your house. U.S. Alliance is a bank. I'm not going to say any more because I don't have the concrete proof. I'm waiting for that as we speak. God bless you. So I thought yesterday, how does what Aiden was saying have to do with Karen? Why does he seem to think that she has some kind of culpability in it? I mean, he's got it so twisted that he has the O'Keefes believing that Karen is to be held accountable for what somebody else said. Has anybody ever looked at it like that? Has anybody ever thought about that? Obviously, no one has, and neither have I, because I've been wrapped up in, other matters. But I've got some notes I took, a few things that I wrote down, and I went through the laws. It's going to be a little bit long. I might pause in between. I don't know. I might do it in 2 series. I'm going to go for as long as I can go because I cannot sit still that long. It doesn't really happen. So say you wake up one morning and you find out that someone told the police that you committed a crime you had nothing to do with. Maybe a former friend called in a theft report. Maybe an ex filed a domestic violence complaint that never happened. Your name is now in a police system, your reputation is cracking, and you're wondering about one thing. Is it even legal for someone to do that? Here's what surprises most people and things that people don't think about much. The person who made that false accusation could face criminal charges themselves. In every single U.S. state, knowingly filing a false criminal report is a crime. Some states treat it as a misdemeanor. Others can bump it into a felony, depending on the type of accusation and depending on the type of case that is involved, which just so happens to be the death of Officer John O'Keefe. This is serious. There's an article that I came across when I was looking into this, and it breaks down what a false accusation is thought to be illegal, what penalties look like across the states in 2026, how defamation and civil lawsuits fit in, and where the legal line sits between a genuine mistake and a criminal lie. You'll see the real statutes and penalty ranges and the scenarios that matter most. Yes, it is illegal to falsely accuse someone of a crime when the accusation is made knowingly and intentionally to law enforcement or a court. Every U.S. state and the federal government treat this as a criminal act, at least where I'm from. Picture someone calling 911 and telling officers their neighbor broke into their house, knowing it never happened. That caller hasn't just wasted police resources, they've committed a crime. In most states, this falls under filing a false police report or making a false statement. Under federal law, 18 U.S.C. Section 1001 makes it a crime to knowingly make a false statement to any federal agent or agency. The feds. The word that matters most here is knowingly. If someone genuinely believed a crime occurred but was wrong, that's typically not illegal. The law targets people who lie on purpose. That distinction between a mistaken belief and a deliberate lie is the hinge on which the entire legal question turns. In California, the penal code makes it a misdemeanor to file a false police report. In Texas, the penal code covers false police reports to peace officers. The New York penal code classifies filing a false police report as a Class 8 misdemeanor, which can carry up to a year in jail. Essentially, each state can make their own penalty signed into law. Duh. Legal exposure isn't limited to criminal charges either. A false accusation can also open the door to a civil lawsuit for defamation, malicious prosecution, or both. So the answer is straightforward. Lying about someone committing a crime is illegal, and the consequences are serious. Think about a store owner who sees someone acting suspiciously near the cash register. They call the police. Investigations find no theft occurred. That store owner hasn't broken any law. They reported what they honestly believed was happening. The legal system is designed to handle situations like that and vet whether or not it applies. It's like as far as without punishing reporters is what I meant. What makes an accusation illegal is intent. If the store owner knew nobody stole anything but called the police anyway because of a personal grudge, that crosses the line into a false police report. The question isn't whether the accusation turned out to be accurate. It's whether the person making it knew the truth and lied anyway. Courts look at several factors to distinguish a protected report from an illegal false accusation. Did the accuser have a reasonable basis for suspecting a crime? Did the accuser know the accusation was false at the time they made it? Was the accusation made to law enforcement in court or published publicly? So if you're wondering whether simply accusing someone could put you in legal trouble, the answer is only if you knew the accusation was false when you made it. Therefore, before you make accusations like that, you need proof. They haven't been charged with a crime. They haven't been found guilty of anything. They are a private citizens, and are to be treated as such. Who the fuck are you, TB? That's what I want to know. When did you become God? Falsely accusing someone, even outside the context of a formal police report, can carry legal consequences. The law's reach extends beyond the police station. Let's see, imagine posting on Facebook that your neighbor is a child predator when you know that's completely untrue. You haven't filed the police report, but you've potentially committed defamation, which is a civil wrong that can result in lawsuit for damages. In some states, certain types of false public accusations can also trigger criminal defamation statutes. Though these laws are rarely enforced, it wouldn't be out of the norm to trigger that during a murder trial of a Boston police officer. The context of the false accusation has to be to police a 911, in court or a sworn statement, on social media or publicly, to an employer or school, to a federal agent. The FBI and the IRS do not fall under these guidelines. The FBI and the IRS can do what they want. They don't need to ask your permission for shit. The feds and the IRS have what it takes to take what you have. Remember that and let that sink in. Potential legal consequences: perjury, civil defamation, civil lawsuit, federal criminal charge. Who can take action? State prosecutor, state or federal prosecutor, the accused person, or federal prosecutor. I think I already said that. Even without a police report, a false accusation can trigger civil liability. Courts have awarded significant damage to victims of defamation. The key factor remains intent. The accuser must have known or recklessly disregarded the fact that their statement was false. So yes, falsely accusing someone is illegal or at least legally actionable, whether you do it in a police station, a courtroom, a workplace, or a social media post. When someone falsely accuses you of a crime, the immediate consequences fall on you before the legal system catches up with the liar. You could face arrest, interrogation, or even formal charges before the truth comes out. Consider someone who gets falsely accused of assault by a vengeful ex-partner. Police responded to the report. They make the arrest of the accused person based on the complaint alone. And if the charges are dropped a week later, that person now has an arrest record, may have spent the night in jail, and could have lost their job. Here's a rough timeline of what typically happens. The false accusation reported to police. The police investigate, question the accused, make an arrest. Prosecutor reviews the case and decides whether to file charges. That's called probable cause. If evidence contradicts the accusation, charges can be dropped. The accused can then pursue legal action against the false accuser. The damage from a false accusation can be enormous, even when the system works correctly. Lost wages, attorney fees, reputational harm, emotional distress, and strained relationships are all common. In Brian Banks's high school profile case, a false rape accusation cost him a college football scholarship and 5 years in prison before his accuser recanted. The accused person has legal options once the dust settles: filing a civil lawsuit for damages, pushing the prosecutor to charge the false accuser, and pursuing a malicious prosecution claim are all on the table. The legal system does offer paths to justice, but the road is often long and expensive. Legal bottom line: a false accusation can wreck your life before the truth surfaces, but you have the right to pursue both criminal charges and civil damages against the person who lied. Let me see, that doesn't even matter here. The trend across states in 2025 and 2026 has been toward tougher enforcement, particularly for false reports that waste emergency resources or lead to SWAT-style responses. Several states have passed or updated state statutes specifically targeting swatting as a separate, more serious offense. Maybe that's why Jess gave a fuck. Maybe. Prosecutors have discretion in these cases. Some officers prioritize false report charges, others don't. Your chances of seeing criminal charges filed increase dramatically when you can show clear evidence that the accuser knowingly lied. Text messages where the accuser admits that lying is particularly powerful. Witness testimony from people with the accuser confided in also helps. Keyword, confided in. Even if the prosecutor declines to file criminal charges, your civil options remain open. You can sue the false accuser for defamation, malicious prosecution, intentional infliction of emotional distress, and the civil cases require a lower burden of proof than criminal. So a case the prosecutor won't touch can still succeed in civil court because the access to records and more discovery is better in civil. You can't file criminal charges yourself, but you could report the false accuser to police, supply evidence, and pursue a civil lawsuit to recover your losses. Yes, you can sue someone who falsely accused you of a crime. Civil lawsuits for false accusations are filed regularly in U.S. courts, and victims can recover damages for financial losses, reputational harm, and emotional distress. The most common civil claims and false accusations are defamation, if it's libel, or it's libel if it's written, slander if spoken. You must prove the accusation was false. The accuser knew it was false or acted recklessly, and the statement caused you harm. Malicious prosecution. You can prove that the accuser initiated a criminal proceeding against you. The case ended in your favor. There was no probable cause, and the accuser acted with malice. Intentional infliction of emotional distress. You must prove the accuser's conduct was extreme and outrageous and caused you severe emotional suffering. A tortious interference is if the false accusation costs you a job, a contract, or a business relationship. You may claim the accuser intentionally interfered with that relationship. Damages and false accusation lawsuits can include lost wages, attorney's fees, medical bills, blah, 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 blah. I want to hit the journalist part of it too. Think of a coworker who tells your boss that you've been embezzling money from a company. Completely untrue. Harms your reputation or your employment. Could be defamation. Specifically, a spoken false accusation is slander. And a written one, like an email or a social media post, is libel. To prove defamation based on false accusations, you generally need to show the accusation was a statement of fact, not opinion. The statement was false. The statement was communicated to at least one other person, not just to you privately. The accuser acted with negligence or actual malice regarding the truth. The statement caused you identifiable harm. There's an important shortcut here. In most states, falsely accusing someone of a crime is considered defamation per se. That means that the statement it doesn't really cause any inherent damage or, from the accusation. So this makes criminal accusations one of the strongest types of defamation claims. The actual malice standard was established in a New York Times Company case versus Sullivan, which applies when the person accused is a public figure. In those cases, the accuser must have known the accusation was false or showed reckless disregard for the truth. For private individuals, the standard is typically just negligence. The accuser should have known the statement was false. Malicious prosecution is a civil claim. You can bring it when someone deliberately uses the criminal justice system against you with no valid basis. You get found not guilty, you can go after them. To win a malicious prosecution case, it's the same thing. Civil cases, weaponizing perjury is always a felony under federal law. It carries up to 5 years in prison, not jail. It essentially strikes the foundation of the court system. The entire justice system relies on sworn testimony being truthful. False statements to federal agents carry especially steep penalties. Lying to an FBI agent, IRS investigator, or any federal official can result in up to 5 years in federal prison. This is the statute that has been used in numerous high-profile investigations where individuals lied to federal agents during interviews. Making false statements to local police is typically charged under state law and is usually a misdemeanor for a first-time offense. However, if the false statement leads to an arrest, prosecution, or other serious consequences for an innocent person, prosecutors may add additional charges. Posting a false criminal accusation on social media can expose the poster to defamation lawsuits and, in some circumstances, criminal charges. Social media platforms do not provide legal immunity for false statements of fact. Consider someone who tweets, "Blank name stole $10,000 from our nonprofit." If that statement is false and the poster knew it, the person named can sue for libel. The fact that it was posted on X, Instagram, Facebook, or TikTok doesn't change the legal analysis. Written defamation is libel, and social media posts are treated as written statements. Section 230 of the Communications Decency Act protects. No, Bubba, I'm trying to do this right now. I'll come down in a minute, okay? I know I sound serious, guys. Section 230 of the Communications Decency Act protects the platform, like Meta or X. Like, it doesn't essentially protect the user or whatever. That's why there's contracts and all that bullshit. It does not protect the individual user who made the false statement either. You can't hide behind the platform. What makes social media accusations particularly dangerous from a legal perspective? Permanence. The posts can be screenshotted and archived even after deletion. Turtle boy, blackmail. The reach that a single post can have can be seen by thousands or millions, which just amplifies the harm. The evidence can be social media posts which create a clear written record that makes defamation cases easier to prove. The republication. Every share or repost can extend the statute of limitations in some states. Let's see. If you're the target of a false accusation on social media, preserving evidence is your first priority. Screenshot everything. Save the URLs. Note the date and time. This evidence is the foundation of any future legal action. A false accusation of criminal conduct in the workplace can result in civil liability for the accuser and, in some cases, for the employer. Workplace settings add layers of complexity because employment law intersects with defamation and harassment law. Let's see. False workplace accusation can also give rise to legal claims. Defamation. If the false accusation was shared with others beyond the necessary scope of an investigation, it may be defamatory. Tortious interference with employment. If the accusation caused you to lose your job or a promotion, you may have a claim. Wrongful termination. If you were fired based on a false accusation, you may have grounds for a wrongful termination claim, especially if the employer failed to investigate properly. Hostile work environment. Repeated or targeted false accusations could contribute to a harassment or to a hostile work environment. Claim. There is an important wrinkle here. I'm trying to get comfortable in this fucking chair. Okay. There is an important wrinkle here. Many workplace communications are protected by qualified privilege. This means statements made in good faith during an internal investigation are often shielded from defamation claims. The privilege breaks if the accuser acted with malice or knew the accusation was false. Employers also have potential liability. If an employer acts on a false accusation without conducting a reasonable investigation, the employer may be liable for negligence. In 2026, several states have strengthened the employee protections that require employers to conduct fair investigations before taking adverse action based on accusations. Excuse me while I pause. Gotta gloss them up. Palate's a little thirsty. So, I'll be right back. Hey people, I'm back. I just need to smoke a joint here. Pull out the jizoints. I'm not. My dogs aren't getting freaking shotguns over here, so I don't want to be accused of greenhousing while my dogs are. People are fucking so stupid. You know that? Like, you don't pay my bills. You don't own my house. You don't do what I do. You don't have to. Just mind your neck. When it comes to me, what people have found out is don't fuck with Diana. I'm relentless. They've said I'm silent, but I'm deadly. You don't see me coming. But when I come for you, you best believe I'm backing up what I say. And what I say is the truth. So if you don't want to hear the truth, I suggest you fucking beat feet and go check out those other content creators that profit off of Jessica Machado. You don't think I've already reported your content for violating the minors? You do have to disclose if you're going to be bullying somebody, if you're going to be, I don't know, making fun of someone's weight, making fun of their appearance, making fun of them people trying to take them down, making fun of their life, making fun of their money, making fun of how they drink their coffee, whether she's a bagel, whether she drives and yells into her phone. I do the same fucking thing. I yell all the time. All the time. Because you want to know something? When I talk, you bet you're going to fucking listen. Now let me light my joint. So today's plans, I don't know. J7, I watch her, pumps me right up. Gets me ready to, tell the truth. Just a little bit. So what are the plans for today? Well, hopefully I'll put a dent in this shit. So then I can just like do the Lindsay Clancy thing because there's a lot of sketchy shit with that. Not just like doctors and shit, like DNA. My specialty, blood splatter, amount, how it's drawn, the way it's tested, what serums used. Evidence. Evidence. Not just one person's digital framework, if you will. Okay? Not just one side of the story. It's two. So yeah, anyway, as I was saying, it's a little brick in here. I think I'm gonna go head out to Sandy Neck a little later. It's fucking what's today? Tuesday? So yeah, usually won't be that busy. Weekends are a bitch. You gotta get there, like fucking lines all the way down the road, start deflating the tires. But anyway, I can drink my Grey Goose. I can show my dog. I could pump the beats. I can do whatever I want with my fellow Jeep family. Once you're in a Jeep family, there's nothing like it. Nothing. Because you know what Jeeps stand for? Jeeps are military vehicles. Who do you think built Jeeps? Women. Like Rosie the Riveter. While the men were out fighting the war. That's what a Jeep means. The Jeep Wave. It's not just a cool thing. I don't wave. It's not just people think that's what the soldiers used to do when they would pass each other, when they were bringing a victim from one place to the other. That's what Jeeps were used for. That's why the windshields of some of the older Jeeps fold over. Okay? What other knowledge can I spit at you? Yeah, I'm a little disappointed in Valhalla. It's the expert, man. That's some Sally ass shit. For real. All right. Let me put this fucking out. Shall we continue? Can I see? No, see, I can't. I need shades. These are, these are the just shades that I use. What the fuck are these? I got my Jimmy Choos and Christian Dior's. I don't wear blue blockers. I think my dad does. So, shall we continue? Excuse me. Now, I think we left off on the whole hostile work environment claim that can contribute to harassment or a hostile work environment. There's a wrinkle. Many workplace communications are protected by a qualified privilege. This means statements made in good faith during an internal investigation are often shielded from defamation claims. The privilege breaks if the accuser acted with malice or knew that the accusation was false. Sorry, it's some good weed. Employees have potential liability. They also have potential liability If an employer acts on a false accusation without conducting a reasonable investigation, the employer may be liable for negligence. The legal bottom line is false accusations at work lead to economic harm, which make economic harm. The legal system draws a clear line between a false accusation and an honest mistake. An honest mistake is not illegal. A deliberate lie is. Okay, let's see. Courts examine the totality of the circumstances. They look at what information the accuser had at the time, whether the accuser had any motive to lie, Turtle Boy agreed, and whether a reasonable person in the same situation would have reached the same conclusion. According to Turtle Riders, the answer is yes. Many states also have the Good Samaritan or good faith reporting laws that specifically protect people who make honest reports to law enforcement. These laws exist because the system needs people to feel safe reporting suspected crimes, even if their suspicions occasionally turn out to be wrong. The gray area arises when someone is reckless with the truth. If a person makes an accusation without caring whether it's true or false, some jurisdictions treat that recklessness as sufficient for civil liability, even if the person didn't technically know the accusation was false. Proving a false accusation requires evidence, as we all know. The accuser has to prove that he knew the claim was untrue and that at the time they made, proving a false accusation requires evidence that the accuser knew that their claim was untrue at the time they made it. The burden of proof shifts depending on whether you're pursuing criminal charges or a civil lawsuit. Say you've been cleared of a false theft accusation and now you want to hold the accuser accountable. You need to build a case that shows the accuser intentionally lied. This is what it looks like. In practice, common sense investigator, text messages or emails where the accuser admits the accusation was false or discusses plans to fabricate the accusation. Witness testimony from people the accuser told. Witness testimony from people who the accuser told the truth to before or after making the false report. Alibi evidence is proven you couldn't have committed the alleged crime, such as GPS data, surveillance footage, time-stamped receipts. Inconsistencies in the accuser's story that demonstrate fabrication. Motive evidence shows the accuser had a reason to lie. Custody dispute, financial gain, revenge. Would you believe it? Recantation. If the accuser later admits that they lied, either voluntarily or under pressure. In criminal cases, where the prosecutor charges the accuser with filing a false report, the standard is proof beyond a reasonable doubt. That's a high bar. In civil cases, where you can sue the accuser for defamation or malicious prosecution, the standard is a preponderance of the evidence, meaning you only need to show that it's more likely than not that the accusation was false and it was intentional. Let's see, states like Texas and Florida have spotlighted and have allowed circumstantial evidence, such as a clear motive plus inconsistent statements, to support a finding of intentional falsehood. In California, the accused person can use the accuser's prior history of false reports as evidence, though it rules out about character evidence by way of jurisdiction, but not if it's like a pattern, proof of bad act. That wouldn't come into play. Documentation is everything. Like I said, start collecting. You guys know what documentation is. Lying to the police about someone committing a crime is a criminal offense in every state. Penalties typically include 6 months to a year in jail. It's a misdemeanor. Federal law adds 5 years for the false statements to federal agents. The punishment, we know what it is. You go to fucking jail. You know, can I sue someone who falsely accused me of a crime? Of course you can. We all know you can. Where is it? Where is the rest of it? I know it was longer than that. Hang on a second. We're having a glitch here, guys. Glitch. Might be. Oops. All right, you know what I'm gonna do? This is what I'm gonna do. I am going to just go on where I got my information. Hold on. Because I ain't gonna go digging for this shit. Then I'll get freaking set off and whatever. All right. Let me see. What's a good one? New York Times Magazine. No, I want the how a lie a con artist snitch. No, that's not the one I want. Ich werde. Wait, I can just fucking go to history, right? Am I right? Am I right? I'm right, right? Okay. I don't want that. I want the Karen. I want, which one was it, Matt? The fuck? I'm getting aggravated now. See, this is why I can't go live. This is why Diana cannot go live unless I don't have a script to follow. Because okay. I'm just gonna freaking, here we go. Let's just fucking stop playing games. Come on, D. You ain't that dumb, D. You can't be that dumb. Come on, D. Can't be that. Okay. In Abigail, Louisiana. Okay, that's not the case that I want. Okay. ProPublica is usually a good one, but uh, really, I did this well last night. I did this pretty well last night. The fuck is going on here? Recently closed. Tabs. No, I don't have other devices. What are you doing? Okay. Like this is what happens when I get high. I forget what the fuck I'm doing. Okay. think this New York. But give me a second, guys. Give me a second. It's like it's not exactly what I want. I think it's like the journalist fucking shit that I want. For the love of Christ. Okay, here we go. All right. This is I get this from a website. It's called the United States Courts. It's a federal website. Everything I use is federal. Just in case. So the opening statements, witnesses, exhibits, transcripts, motion to quit, jury instruction post. And then there's a part here where it asks handbooks and reports, statistical reports. Hang on, I'm just making sure what I'm reading is correct because I'm not wasting my fucking time. Jury deliberations. Access to evidence presented in the court. Now, what I want to know is, I had it. I fucking had it. Reported on covering criminal trials, civil trials, judges, and judicial administration. A journalist's guide to federal courts, post verdict. I think let's do federal court media basics. That should have it. All right. Federal courts are public institutions with rare exceptions. Members of the media and public can enter any courthouse and any courtroom. However, whether you're reporting about a high-profile case or the federal courthouse is part of your beat, the judiciary has distinct differences from the other branches of the federal government, which often affect a reporter's experience. In legal terms, reporters do not need a degree to cover the federal courts. It's essential to understand and be able to translate legal jargon and procedures. For like readers or viewers, in my case, you're my viewer. Substantial autonomy to determine local rules and practices. Federal judges adhere to strict ethics guidelines and recuse themselves from cases that constitute a conflict of interest or in which their impartiality might reasonably be questioned. Official proceedings, media access, and brief. Hold on. Okay, so media access and access, like court documents, they're filed electronically in appellate, district, and bankruptcy courts, and they're available through public access to court electronic records like PACER. So interviews, like such as judges, court staff, jurors, may not discuss active cases. The clerk's office usually as a court's designated point of contact with the media. Courthouse security. Members of the public must pass through a metal detector. We know all that. Well, courtroom access. closed sessions. Certain proceedings are always closed to the public and media. By rule, only a witness, attorneys for the government, and a court reporter may be present when a grand jury sits, and jury deliberations and attorney-client meetings also occur in private. These rules are designed to protect the integrity of the process and preserve the right to a fair trial and an impartial trial. Proceedings that deal with classified information, trade secrets, and ongoing investigations and ongoing where the fuck did I just these rules are designed to protect the integrity of the process and preserve the right to a fair trial. Proceedings that deal with classified information, trade secrets, and ongoing investigations are often closed, like case closed, like records, the session, closed door sessions, whatever. Judges also may meet privately with attorneys in their chambers. Most pre-trials are open to the public. Journalists should not cross from the public gallery into the well of the courtroom, which is generally marked by a short rail. Journalists should obey posted restrictions and instructions from court security officers. Recording and broadcasting. The use of cameras in federal courtrooms is governed by the Judicial Conference of the United States and federal rules of criminal procedure. There's a whole policy on cameras. In specific instances, such as investors, naturalizations, or other ceremonial proceedings, a judge may permit the public and media to take photographs and conduct video and audio recording inside a courthouse. And by local rule, the Second and Ninth Circuit Court of Appeals will consider media requests to record or broadcast an appellate proceeding. Outside these limited exceptions, the media may not photograph, videotape, or record live federal court proceedings. Courts of appeal may provide audio or video recordings of appellate hearings. And like all the rules are available on each circuit's website. Let me see. Some district bankruptcy, whatever. It is important to note that the prohibition on recording includes the use of cell phones and other personal electronic devices, even in courthouses, where the public is permitted to carry such devices. Journalists must not record or photograph trial-related activity, either in the courtroom or in areas where closed circuit audio or video is available. Violation of this rule can result in significant court sanctions. Under local rules, courts may specify areas away from the courtroom where cameras can be used for interviews and TV reports. These areas are usually outside the courthouse or just outside the federal court property. Electronic devices. Circuits and districts set local rules on whether the public and media may bring portable electronic communication devices, such as cell phones, laptops, and tablets, for all you turtle riders, into their courthouses, and whether such devices may be used. May is the key word. May be used. It's a privilege. For guidance on personal electronic devices, consult the local court's rules, administration, whatever. Even if a court generally permits electronic devices, individual judges still may prohibit them inside the courtrooms. Judges also may limit the applications that may be used on such devices. For example, if the devices are permitted by the court rules, a judge may prohibit live blogging or using the use of social media applications inside the courtroom. Let's see. Reporting on criminal cases. Criminal cases involve an allegation by the government that an individual or entity violated the criminal laws of the United States. Investigations and related documents. Although a defendant may be arrested during the commission of a crime, most criminal cases that attract media attention begin with a federal investigation. Generally, this involves the U.S. Attorney's Office in coordination with law enforcement agencies, such as the FBI, the Drug Enforcement Administration, or the Securities and Exchange Commission. May I make the point that Joshua Levy dates Marietta Sullivan? Again, Joshua Levy, the former acting U.S. attorney, who is banging Marietta Sullivan. Most investigations remain confidential, with prosecutors and investigators presenting evidence in closed session to a grand jury. A magistrate judge or a district judge may authorize search warrants, also in closed hearings. Warrant applications remain sealed until the search is conducted, and sometimes until after the arrest is made or the investigation is closed. Courthouse beat reporters may find it useful to review unsealed warrants regularly, as the application documents can provide an early window into the facts of a criminal investigation. In particular, a supporting affidavit written by the lead law enforcement agent to supply the judge with evidence of probable cause offers a detailed account of the allegations. The one-page warrant application includes information about the defendant. The clerk's offices maintain a search warrant application in a variety of ways. Grand juries and indictments. In most federal felony cases, prosecutors present evidence to a grand jury. Grand juries are composed of 16 to 23 citizens who hear a wide range of criminal cases and decide whether there is evidence to justify indictments sought by federal prosecutors. Grand juries can be seated up for up to 18-month terms. That's 18, 1-8. But their service can be extended an additional 6 months if needed by an order from a district judge. Grand juries are supervised by a judge, often the chief judge, but for all practical purposes, they function from day to day under the auspices of the U.S. Attorney's Office. Only prosecutors present evidence before a grand jury, and neither the accused nor his or her lawyer is present when a grand jury meets. An indictment is a roadmap to what the prosecution intends to prove at trial. To return an indictment, a minimum of 12 members of a grand jury must find probable cause. Grand jurors are prohibited from discussing the case-related information with the media or others. Grand jury indictments are returned to the district court, usually to a magistrate judge, in a closed court hearing, and often are sealed until the arrest is made. The indictment lists the offense that were allegedly committed by the defendant, describes the facts supporting those allegations, and it's what the prosecution intends to prove trial. That's why the feds get 99.9% conviction rate, because the motherfuckers don't play. All right? Feds don't play. Felony preliminary hearing proceedings. The defendant's arrest, when it follows a felony indictment begins a series of 3 preliminary proceedings in open court. They are the initial appearance, the detention hearing, and the arraignment. The first 2 are always before a magistrate judge. The initial appearance must take place without unnecessary delay under Rule 5 of the Federal Rules of Criminal Procedure. And it typically occurs within hours of an arrest. The defendant is advised of the charges, his or her rights are explained by the judge, and counsel is appointed if the defendant cannot afford a lawyer. Unless you freaking beg for money like every day, or Amazon wish lists, or fundraisers that don't happen, or, unless, then you can afford a lawyer. The prosecutor also is asked whether the government will seek to detain a defendant pending trial. If the answer is no, the magistrate judge will determine any conditions of release and order the defendant freed. If the prosecution seeks to hold the defendant, a detention hearing will be scheduled for 3 days after the initial appearance. That's in accordance with the Bail Reform Act of 1984. The detention hearing determines whether the accused must be held in jail until trial. Prior to the hearing, a pretrial services officer files a report with the judge based on interviews with the defendant, family members, and others who have relevant information. The report, which recommends whether the defendant should be released and under what conditions, is not public, and it is not binding on the magistrate judge. But if the judge releases a defendant pending trial, the conditions of release are listed in a court order, which is public. During the detention hearing, both sides may present evidence and cross-examine the other side's witnesses. Federal law, there's that word I fucking love. 2 words. Federal law requires that individuals be released on personal recognizance or unsecured appearance bond. That is, without putting up any money or other assets as security, unless, under the Bail Reform Act, the judge determines that such release will not reasonably assure the appearance of the person as required, or will endanger the safety of any other person or the community. If the judge determines that a person presents a flight risk or a danger to the community, the judge still may order release subject to certain restrictions, such as requiring a secured bond, forfeiture of passport, electronic monitoring, or home confinement. The Bail Reform Act requires that a judge choose the least restrictive conditions that protect the community and ensure the defendant's appearance in court. We all know that's a fucking lie. They don't give a fuck. I had a leg bracelet on. You kidding me? Randoms. Are you kidding me? What did I do? I fought against needle exchanges in sober homes, political officials. That's who filed police reports on me, were people that I pay. Under certain circumstances, a judge is to presume that a defendant cannot be released safely. These include cases that involve an act of terrorism, federal drug offenses carrying a penalty of 10 years, drug trafficking, and certain offenses involve minors. The accused may present evidence. Once a magistrate judge has ordered the detention or release of a defendant, either party can obtain a review of that decision by a district judge. The arraignment is a formal reading of the charges. In response, the accused is expected to enter a plea of guilty or not guilty. At this time, the accused may request a jury trial or a bench trial before a judge. Some judges also schedule the trial date and dates for motion hearings at the arraignment. Criminal complaints and information. Hang on, it's my mother calling. Sorry, when the greenhorn calls, you must answer the phone, especially if you've been logged out of your house before and your father didn't even know. That was fun. I got to go in like 15 minutes to go eat. I'll just pause it and then just finish it after. Criminal complaints and information. A defendant can be arrested without an indictment. When an arrest is made during the alleged commission of a crime, the lead investigator submits a written criminal complaint. In addition, a federal prosecutor may, without going to the grand jury, file charges in a document called a criminal information, which is information that sets forth the same kinds of allegations and facts that would be contained in an indictment. Pretrial motions to dismiss charges, suppress certain evidence, relocate the trial, change of venue, claiming for instance, pretrial publicity in the local news and media that will make it impossible to select an impartial jury. Competency motions asking a judge to postpone the trial on the grounds that a defendant is not able to understand the proceedings or to assist in his or her own defense. Essential elements of a fair trial. If such a motion is granted, all trial activity ceases, and there is no determination of guilt or innocence. A trial may occur at a later date if the defendant's legal competence is restored through medical or other treatment. I have a feeling they're going to section his ass. I got sectioned. I met some good people. This phase of a case is known as motion practice. A judge may decide motions based purely on written briefs or set a hearing if oral argument of the issues or evidence from the witnesses will aid in the decision. Guilty pleas. Nearly 90%. Oh, I was wrong. I take 9.9% back. Of federal criminal cases are resolved by a guilty plea. Finito. Done. Slam. Done. The defendant pleads guilty and goes before trial in exchange for the prosecution. We all know there's a rat. There's usually rats involved. I'm gonna get a tattoo, right? It's gonna be like a telephone pole, and there's gonna be chains. No, and the rat's gonna be like held up like by the chains, like getting choked. And underneath that rat, there's like a piece of cheese that he's trying to get at. Like, I need that tattoo. I'm gonna get it. I'm gonna get that tat. I fucking hate rats. Ultimately, a judge must approve the terms of the plea agreement. All right. Let's say district courts reporting covering criminal trials, covering cases, appellate, bankruptcy, other judicial. Let me see, federal. There's can't see. Dude, this must be like in Chinese because I have no idea what I'm doing. I cannot see. The only reason I can read that is because it's dark. My screen's dark, and I got it like bright yellow with like the biggest like font you can freaking possibly think of. So that's how that happens. I keep looking at us. Okay. Here we go. Meat and potatoes. There is no public record of a journalist being blamed by a murder defendant for statements they made. The available news reports do not describe a situation where a journalist's public comments were directly attributed to or blamed by a murder defendant. The chosen closest relevant case in the provided results is the United Healthcare CEO murder case, where a federal judge scolded Justice Department officials for publicly commenting on the guilt or innocence of the accused, Luigi Mangione. Another case, okay, is a Egyptian. All right, no, I don't want that. I want to get down like meat and potatoes here. No, that's a dead man's. This might be it. Oh, okay, here it is. Got it. Got it. Okay. So, I use it. This is the American Journalism Framework. The U.S. Supreme Court has generally granted leeway for journalists and journalistic outlets to publish or say inaccurate things, as long as the errors are made in good faith. Much of the relevant case law within the context of journalism falls under the umbrella of libel, which refers to the publication of a false statement of fact that seriously harms someone's reputation, whether it be regular or oral speech that is not published, with publication being anything from printed news article to a broadcast story that repeats or tweet or whatever that falls under slander. Libel is one of the main legal threats. I can't say. One of the main legal threats that are thrust upon journalists when they publish critical information. It is therefore important for journalists to be well versed on the legal requirements for advancing a libel suit, as well as the classes of defenses that journalists can offer. So, proven libel. They require the plaintiff, injured party to prove, different things. They must prove that defendant published the defamatory statement, meaning that they distributed it to someone besides themselves and the plaintiff. There is to someone besides themselves and the plaintiff. There is no requirement that the statement be distributed broadly or to the general public. Simply posting it on a small private signal group may be enough. Second, the plaintiff must prove that a reasonable person will infer that the statement about the plaintiff is about the plaintiff. Okay, so in other words, they're inferring, of course, well, it is because they're saying names, so it can't infer, information's already there. Okay, that makes sense. As long as there is enough identifying information. Third, the plaintiff must prove that the statement harmed their reputation. For example, if a statement alleges that the plaintiff is gay, no, that I'm not talking about you, Chris Matei. And the plaintiff can show that someone began treating them differently as a result of that information. Fourth, the plaintiff must show that the statement was published with some level of fault. Fault requires that the defendant either did something they should not have done or failed to do something they should have. Finally, the plaintiff must show, can't be late to grandmas, to vavos. Finally, the plaintiff must show that the statement was published without any applicable privilege. A number of privileges may be available depending on what was published by the defendant and the source that they relied upon for the information. Within journalism, the most common defense against the charge of libel is truth. If a statement is truthful, then it doesn't matter if the plaintiff is harmed. For example, for an article claiming that Dr. Something clubs baby seals for fun, and he's a piece of shit. He belongs in jail. Even if the publication was fewer than students taking classes, it doesn't matter. So, for the record, I do not club baby seals, nor do I recommend it. Okay. Notably, the burden of proof is generally on the plaintiff to show that a statement is false. That example, they would have to show there's no evidence and there's no video, engaged in an act, that there's not enough to summarily dismiss the libels. In some circumstances, the burden of proof may fall to the defendant. Think of that, did you? Statements of pure opinion, which cannot be proven true or false, cannot form the basis of defamation claim. The assertion that is a jerk is clearly a statement of opinion and could not serve as the basis of a libel. However, saying that he's a jerk because he clubs baby seals involves a statement of fact. And if that statement of fact is true, is false, then you're fucked. Public and private figures. Trying to see if this paragraph matters. Yeah, it does. Two particular Supreme Court decisions have clarified the libel protections and responsibilities for journalists. In New York Times versus Sullivan, the Times was alleged to have committed libel by publishing a full-page advertisement by supporters of Martin Luther King Jr. that criticized the police in Montgomery for their mistreatment of civil rights protesters. The ad had a number of factual inaccuracies, such as the number of times King had been arrested during the protests, and the Times subsequently published a retraction of the advertisement. Although he was not named in the ad, Sullivan argued that the inaccurate criticism of actions by the police in the ad was defamatory to him because it was his duty to supervise the police department. In a unanimous decision, the court ruled that the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials, except when statements are made with actual malice, which is with knowledge. They can be true or they can be a lie. So, in order for someone to be called a M-word, they have to be charged or found guilty. And has any of that happened? I mean, I smoke good weed, but I'd have to be something. Put another way, when it comes to public officials in the context of carrying out their public duties, the plaintiff must show that the journalistic error was due to an intent to harm the official or as a result of recklessness, meaning a journalist plainly disregarded information that should have been evident to them. This is a high bar, as it can be immensely difficult to prove a journalist's intent to harm. Later cases extended the actual malice standard to encompass public figures, which include not only public officials, but anyone who has gained a significant degree of fame or notoriety in general or in the context of a particular issue or controversy. This may include celebrities, athletes, or regular citizens who become embroiled in highly public debates. There it is. Let's see if that matters. Although the editor of the publication conceded the errors and stated that he had made no independent efforts to verify the claims. Keep looking at the clock. You got to be on time. He countered that the publication did not involve actual malice and was protected under the New York Times versus Sullivan standard, which in a 5-4 decision, the Supreme Court ruled that public figures had access to more resources and ways to defend themselves than private citizens. Therefore, public figures should be held to a higher standard in libel cases. The court further held that states could formulate their own lower standards of libel for statements made about private figures. In practice, this has resulted in a lower standard for private figures across the U.S., with private figures having only to show that a journalist was negligent or that they failed to engage in basic journalistic practices like trying to verify basic information prior to publication. Although journalists who follow best practices, not Aidan Proctor, receive robust protections against libel, they must nevertheless sometimes weigh the threat of a libel suit. Even if a journalist is well positioned to defend themselves, the legal process can be expensive. Again, you ain't paying for it. Several powerful figures have wielded libel lawsuits as a weapon against critical journalism, knowing that even an unsuccessful lawsuit is likely to make other journalists think twice about writing critical stories about them in the future, while some states have enacted laws penalizing frivolous lawsuits in recent years. They nevertheless continue to serve as a powerful weapon for silencing journalists. I think we all get that. So, you know what I'm going to do is we're going to stop here. Wait, I just want law and ethics. Okay, so we'll go to the First Amendment. Okay, I'll read a little bit of this. Okay. The First Amendment is the cornerstone of journalistic freedom in the United States. It states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peacefully to assemble, and to position the government for a redress of grievances. Initially, the First Amendment applied only to laws enacted by Congress. However, over time, the courts have interpreted its provisions more broadly to encompass any form of government interference. The First Amendment is relatively distinctive in that few countries offer such unequivocal statements of support for journalistic work within their legal framework. Now, let's talk about the roots of the First Amendment. Thomas Jefferson, he was gained independence from Britain. U.S. history teacher, you should know this. He championed a document that would protect individual rights and would educate citizens about their rights and responsibilities within the newly formed democratic republic. It is not an accident that the First Amendment and its protection of speech and the press leads the Bill of Rights Jefferson himself wrote. Our liberty depends on the freedom of the press, and that cannot be limited without being lost. Alongside Jefferson, Madison played a significant role in getting the state of Virginia to adopt its statute for religious freedom. Okay, we know that. You're a fucking history buff, aren't you? First Amendment in the Supreme Court. Despite the First Amendment's unequivocal language, Congress and state legislatures have passed a number of laws that abridge the freedom of speech of the press. Put another way, in trying to promote other ideals such as national unity and contemporary notions of decency. Legislative bodies have adopted many laws that infringe on speech and press freedoms. In instances where the First Amendment, geez, my voice just cracked. In instances where the First Amendment clashes with other interests, the U.S. Supreme Court is often the final arbiter over what constitutes an acceptable infringement on speech or the press. Since 1804, there have been nearly 900 major rulings by the U.S. Supreme Court and other courts that directly involve First Amendment freedoms. So I'm going to stop right here, which I'm just going to stop here because I got to bounce. But basically, I set out to see if Karen is in any way liable, could be blamed for statements that a journalist made. If a defendant who is on trial for murder is allowed to make statements to journalists or talk to whomever they want, but for a journalist to talk all that shit and then blame the defendant who's on trial for murder, it's not only unprecedented, but it doesn't happen. I'm out. Stay tuned for part 2. Bye, guys.